All right. Welcome to the show. I am your host, Daniel, and today is Judge Stephanie Boyd. Like I said, please don't think I'm antisocial. I'm having to watch what's being presented to you so I can skip ads because the ads, music and ads, will get you copyright struck on YouTube. So I'm trying to avoid that as much as I can. So let's get started with Judge Boyd. Share screen. Make this bigger. And
Lindsay Tariano, custody. Brian Matthew Mahan.
He's gonna be on via Zoom, Judge.
All right. And let me see if he's here. Yes, he is. Brian Maham by Zoom.
I'm here for him, Judge. We'll confer.
All right, thank you. Natasha Manning. Esther De La Fuente. Henry Rodriguez V. Andrew Thomas Reyes. John Cruz, custody. Robert Moreno, custody. All right, Henry Rodriguez, we don't do the hugging thing in court. That's okay. Brianna Lorraine Luna. Brianna Lorraine Luna. Noah Alexander Oliveira. I'm sorry, Olvera. I think I'm mispronouncing your last name. I'm sorry.
I'll check on it.
Thank you. Robert Marino, custody. Ricardo Cantu, custody. Brandon Ray Ramirez. Kimberly Cuevas. All right, thank you. Ronnie Demas. Ronnie C. Demas.
He's in custody, Judge.
All right, thank you. Roger Talamontes. Roger Talamontes II. Jonathan Lopez Navarro, custody. Leslie Diane Collins, custody. Ruben Joseph Medrano Jr. Samuel Alberto Limon. Samuel Alberto Limon. Leslie Diane Collins. Antonio Vasquez, custody. Christopher Lawrence Fields. Christopher Lawrence Fields. Julio Maldonado Guevara, custody. Troy Soba, custody. Miguel Madrigal. Daniel Cotil. Lindsay Tariano. Christopher Falk, custody. Christina Taylor. Jacob Rodriguez. Dorian Murphy, custody. George Abaye. Shades off, please. Willie Cunningham. Thank you. Willie Fields. Willie Damon Fields. John Thurnert. John Arlen Thurnert. Gary Oregon. Gary Dean Oregon. Christian Holguin. Ruben Rendon. Daniel Cotel, custody. Bernice Wilson. Leanne Lamong. Alexandria Alvarez, custody.
He's a virtual procedure.
Your Honor, she is in the Guadalupe County Jail Council's.
All right. Tyler Ketchum.
Judge, I don't believe that we were able to get in contact with him. I'll have a further update later.
All right. Richard Ibanez. Juan Martinez, custody. Raymond Elizondo.
Judge, he should be on.
He is. Thank you. Albert Carl Gunther.
Here.
Shelby Jean Rodriguez.
Judge.
She's here. Dejanette Havana, 130. Is there anyone who came in later? Your name was not called? What's your name? Samuel, and your last name? Limon?
Second row, sir.
Thank you. Anyone else? All right, so these are the rules of the court. Attorneys, if you have somebody in custody, once you request them, do not leave the courtroom. For security reasons, we can only have so many inmates at a time. You're not ready to approach the court unless you've conferred with your client and conferred with the state, because we are going paperless and we have to go paperless. Attorneys, when you're ready, you'll need to sign in. So once you sign in and your paperwork is ready, I will call you. I will call you in the order of appearance. If you have not been called, it's because I don't have the paperwork and I haven't been informed. If your client wishes to speak to the court in a language other than English, you'll need an interpreter. Please let the clerk or coordinator know before you say you're ready that you need an interpreter. Here is criminal trial division. Right here is family violence. We're going to recess at 12 because we have a jury coming up at 11:30. So everyone, it's Tuesday. I know we thought we'd be retired. We are not, but we're still going to enjoy the day. So please confer.
Madam Coach?
Yes.
This is a flood destruction order from the Department of Public Safety.
All right. And do you have any objection?
No, Your Honor, we're facilitating it for them because they're in Austin and they asked the Conviction Integrity Unit to bring it to the judge for them.
Okay. All right. It has a date on here, August 13th.
Yes, that's when it was first sent to us. We came, Angelini was on the bench, wouldn't sign it, so we came back.
All right. So,
I mean, if you want to scratch that out, or you want me to scratch it out and put today's date, that's fine.
all right. Because as you know, whenever I receive documents, I read it over carefully. Then if it's in proper order, I immediately sign it. And I don't want someone to think that I've had this since August.
No.
Okay.
That's- This is literally, the refrigerators are full, and so they're trying to find cases they can destroy, so they can more room, that's literally
All
what
right.
this is.
No problem.
Hold me there, do your red light.
All right. There you are.
Thank you, Judge, appreciate it.
Welcome. Hello. Hi.
I'm here for part of this one, but they didn't bring him. And this
Okay.
one was in custody. And I know you start trial later this afternoon.
Yes. Well, if you can see, because I know that Judge Ron Rangel
Mhm.
has his docket, you can see if they're available
Admitted.
having, yes.
Okay, I can do that and then I'll set him for Friday.
All right.
All right,
And
thank
if
you.
not, I'm sure they'll be able to get him, but it'll be in the afternoon.
Later, yeah.
Yes.
I mean, and I know you're starting your trial and all that stuff. I
No,
won't
I mean,
interfere with that.
but you may want to talk to Ms. Gay.
Yes. Talk to her. Thank
All right. Thank you.
I like that.
I have,
Mr. Featherston?
Almost like, and so. That's not. Sure.
I know, thank you so much.
So.
Modification on the
car.
That car is starting to modify it. It's just.
It's all video in front of.
Even right there.
Truck.
No.
So, oh my God.
Once you go to 5 minutes.
Time with upstairs.
All night. Where do you want it? Oh, calling me. They're gonna drop like. They're going to work out. This part is. Oh, okay. One face for. I didn't hear all.
Yeah.
You'll go out.
There's another question. Arlene, is saying that she could take the paperwork with her and get it signed from Mr. Guzman at the jail. Is that appropriate? Is that okay?
Yeah, I mean, she can have it signed at the jail, but when is this going to take place? That's the problem.
Yeah, she has a docket on Thursday. I mean, she has 9 times that she has to see on Thursday and
We
then
can't
during
have
trial.
somebody sitting at the jail
Yeah.
awaiting to be in the program. So if they're gonna bring him over today, then she'll need to be here this afternoon to take care of that.
Would you be able to do that this afternoon? I know you
So
have jury,
either-
you have a trial.
Because isn't Judge Runhell doing Friday?
Yeah, she says she didn't want, I guess she had free Friday.
I'll try to do it Thursday. I'll make.
Now, I don't have room on my schedule for Thursday.
Okay, so Friday.
Friday is good for.
Okay.
All right, thank you.
Perfect.
All right, I'm ready.
Page 9 or 6.
I won't take off my shoes. I'll just leave it all.
All right, thank you.
But go get your input for reviews.
Okay. It's your. I'll consult and show.
All right, who's here on Alexandria Alvarez? And where is Alvarez?
She is in custody at the Guadalupe County Jail.
All right, everyone, please whisper. Yes.
And so I had spoken with Norma, and so I wanted to ask you how you wanted to have it handled, where she is to attend by Zoom.
All right, do you have any objections to her attending by Zoom?
I don't know.
All right, so here's the question for the court on this case. It says virtual booking, but I'm being told that she's still in custody in another jail. So why is that? Does anyone know?
I do not, but I can see if I can. So I had not heard from the client in a while, and it came to my attention 2 days ago that she was in custody of the Guadalupe County Jail.
All right.
And then I entered a notice of appearance. I had initially represented her earlier this year for the same issues because there was a previous motion to revoke that was on file. So I'm continuing to assist on this matter, but she is in Guadalupe County.
All right, and so have you verified that she's in Guadalupe jail?
I have, yes, and I have that information and I can.
All right, if you can, and do you know, is the reason she's in Guadalupe based upon this case or something in another county?
It's based on the number ones related to these, so these are pending criminal cases. And then her information could be easily verified to the website and then integrity.
All right, so what she's alleged in the motions to revoke, are these burglaries of a habitation? Are they burglaries of a vehicle? What is it?
Multiple counts.
I have not seen the motion today yet. I have not.
All right, so if you'll confer with her very quickly, and then when you're all ready, just come back up.
Sure.
All right. Anyone else ready?
Yes. Yeah, that's one thing. Yeah, that's definitely.
I'm sorry, who?
Esther, I believe, is down the one, page two down.
Okay, thank you.
No, oh, okay. Oh, I haven't talked to you.
Judgment.
Is it something that's on the docket?
Yeah.
Oh, you need to sign in.
Yes.
All right, Esther De La Fuente. Who's the attorney for Esther De La Fuente? Hello. Hi. So today is your plea deadline date.
We're unable to reach an agreement. It's time, Your Honor, arresting for a jury trial.
All right. So here's the thing. Your plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. Otherwise, you're going to have to plead open to the court. Do you understand?
Yes.
Oh, I'll just wait till you finish with your phone.
Waiting my calendar, Judge.
Okay.
You're gonna give a date and I'm ready to.
All right. Awesome. All right, Ms. Ferguson, I need a jury trial date. How long do you expect this trial to last, State?
3 days.
3 days. And it's criminal trial division. All right, December 9th is your jury trial date. I need an acknowledgement of discovery signed if that has not been signed. All right, thank you. Just have a seat and your attorney will bring the reset form to you, okay?
Thank you.
All right, thank you.
Judge, I was not trying to, I swear I had my
There's no
calendar.
need to swear to me.
Sorry, I promise and affirm that I was looking at my.
Well, there's no need to promise or affirm. All right, and state on that one, just if there's any updates, because I do have in the system that a previous one was filed and signed.
Okay.
All right, who's next?
Yes, and Michael, one Martinez, page 1 down.
Where's one?
Juan Alberto Martinez.
Juan Martinez. Oh, there you go.
Judge, can we hold off for just a minute? Pre-trial wanted to come down and make an interview with him.
Okay, sure.
We had back in August asked for a PR interview.
Mhm.
Norma sent the proper emails out, but apparently it's kind of slipped through the crack.
Okay,
So
all
they're
right.
coming over.
All right, thank you. Who else is ready? All right, thank you.
Ready on Thursday. Nothing. So, as long as you get the guidelines to the face.
Who is it?
Albert.
All right. And is this a motion to revoke? What is this? All right. Albert Carl Gunther.
Morning.
Hello, good morning. How are you doing today?
Once this is over, it'll be even better.
Hey. I know it's.
I believe you have it.
All right, thanks. All right, thank you. All right, so Mr. Gunther, let me ask you a question. Are you on probation out of this court?
Yes.
Then your actions are showing that you don't think that you're on probation because you're not following through on anything. You're not taking your UAs, and when you're drug tested today, what are the results going to be? Because you're going to get drug tested today. No, what do you mean?
They should be negative.
When's the last time you used?
Been a while.
All right, what does that mean?
Maybe about a month ago.
All right, so what's going to end up happening is you're going to go and do a UA today. And if it is positive, a motion to revoke is going to be filed. So what are your results going to be before I send you?
Negative.
All right, Miss Abrams, we're going to send you to get a UA. Do not stop at any other location but the location that Miss Abrams is going to give you. If you end up going somewhere else, then a motion to revoke may be filed. Do you understand?
Yes, ma'am.
All right, so talk with Miss Abrams. We're going to get a UA from you today.
She is George.
Yes. Yes.
First of all.
And Miss Abrams, you're sending him to. Anyone else ready? All right, thank you.
Just came to February for the
All right, thank you. Oh, she said that you just gave me discovery. All right, thank you. You're welcome.
I'm sorry.
It happens. Oh, yeah, hold on, somebody else.
You know.
Just give me one moment.
Of course. He's here.
All right, who's the next person?
Yes, ma'am. I guess Andrew Reeves.
All right, thank you.
He's been sworn. All
All right, thank you.
Yes.
Andrew Thomas Reyes, is there an application?
Yes, Your Honor.
All right.
There's two cases and it's on both, but they're running CCs. Yes. And their recommendation on it.
All right, I only have one case.
Please.
Two.
I'm sorry, I should have. I did, yes, you did. I apologize.
All right, the court is calling 2025 CR 0119977 and 2025 CR 007562A, State versus Andrew Thomas Reyes. Can I have parties announced?
Pertaining to the state of Texas.
Miguel Hernandez for the defense.
And are you Andrew Thomas Reyes? Counsel, in each cause number, have you received all the discovery and that you review that discovery with your client?
I have, Your Honor, and we have signed a document indicating that we have received all this stuff.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Reyes, in cause number 2025 CR 011977, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes.
Did you understand in that cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not there's enough evidence to hold you over for trial, and also that your attorney has certain rights. Your attorney has the right to have the passage of 2 days once they are presented with the information and 10 days to prepare for trial. Did you understand?
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
All right, off the record, to the clerk. Adriana?
Yes, ma'am.
I don't have the information in this cause number.
Those copies to each one.
Yes, please.
It's just the unofficial signed one,
All right.
unsigned.
And if you can make sure also, Adriana, that you have that.
You did the original one with the paperwork.
All right, we'll need to make sure that we have that before things are done. All right. Did you review the felony information with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, in each of those, are you waiving the reading?
We are, Your Honor.
State, in the cause number that is the felony information, are you proceeding on that information as presented?
We are, Your Honor.
And the other cause number, are you proceeding on in the indictment as presented?
No, Your Honor, we will waive count 1 of the indictment and proceed on count 2.
No objections, Your Honor.
All right, in each of the cause numbers, did you review the documents entitled court admonishments with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes.
And cause number 2025 CR 07562A. You're charged with possession of a controlled substance, penalty group 2, 4 to 200 grams. 4 to 400 grams as a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes.
And the felony information, you are charged with endangering a child through criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Reyes, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if you're not a U.S. citizen, you will be deported, not allowed re-entry and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea in the felony information case, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. This will run concurrent with 2025 CR 007562A. And the other cause number, the state is proceeding on count 2. There's a $2,000 fine. The state recommends deferred adjudication, and it will run concurrently with the previous case. Did you understand that to be the plea?
Yes.
Defense?
It is.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, in the felony information case, the state is asking that your community supervision be for a term of 2 years. There'll be 100 hours of community service restitution, no contact with Skylar Reyes, parenting classes, TAP evaluation, follow all recommendations in the MRT. In the indicted case, the state is asking that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 200 hours of community service restitution, the parenting classes, and moral recognition therapy. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
You said no, Your Honor.
So you understood that?
Okay.
Did you understand that?
Yes.
Then, and cause number 2025 CR 007562A to count two, how do you plead? Guilty, not guilty, or no contest? In 2025 CR 011977, how do you plead?
No contest.
State any evidence.
For both cases, Your Honor, state officers have evidence as exhibit one of all attachments.
We've had a chance to review both cases, Your Honor, and found no objections.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and cite it in both places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Rick,
Yes, Your Honor.
if you'll just sign this and they'll file stamp it.
Sure.
Thank you.
You're welcome.
Oh, thank you.
You're welcome.
All right, in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is taking full responsibility for what occurred in that house and on that evening. Because of that, Your Honor, and because of the fact that he has a clear record, we would ask that that to be taken into consideration. The first thing we'd like to address is that the no contact order, although the state asked for it, we did go through a proceeding with the child custody people, and they found that he has had no problems with his child. So we would ask that he had at worst, no harmful or injurious contact with his child so that he can see his child. He is supporting the child and taking care of all of his bills. Your Honor, he is working at this time. And so we would ask that the judge take that in consideration when considering, since the two cases are in together, the amount of community service hours that he's doing. The TAP evaluations and the other things that I've explained to him were things that are probably good that he has to do. He does not have, they've done follicle tests and all kinds of other things, so he did not have any problems with drug use. And so we believe that'll clear him too, and they'll see all that. But we would just ask consideration on the fine, the no contact order, the no harmful or injurious contact, and consideration on the community hours.
All right, state, you want to be heard on the no contact order?
Yes, Your Honor. I wasn't sure if Your Honor would accept me putting in the harmful injurious contact as an option. But I will say we had the co-defendants about a month ago, if you recall, Jacob.
Yes.
Kelly. And I reviewed the CPS record associated with all three of them, including this defendant, and this defendant seemed to be the most, and he has a CPS, less culpable for the situation. He passed hair follicle very soon, so what they call family plan was cleared sooner than Jacob and Kelly were the other two co-defendants. So state have not had any objection. This particular defendant had no harmful injurious contact with this
All right. So were you living with these other people?
And it was,
So how many rooms did this home have?
3 rooms,
All right. And how many bedrooms?
2 at the time that I know of.
So it
that were
was
being used as bedrooms.
two were being used as bedrooms?
Yeah, the other room I did not know what
All
was
right.
being
So
used.
where were the adults sleeping? Did the adults have a designated bedroom?
They did, but I know a bed frame like broke in the room, as they told me, so they're like living in we're sleeping in like the living room area. So
So I'm just wondering, why would you all be growing marijuana in a child's bedroom?
I'm sorry?
Why would there be marijuana grown in a child's bedroom as opposed to an adult bedroom?
From what I was being told, one adult bedroom, it was being grown, and in the other room, I'm not sure what was being done in that room.
No, I mean, it was being grown next to a crib unless the adults are sleeping in cribs.
I understand. Yeah.
So did you and nobody say, hey, you know what? We're gonna go ahead and grow this marijuana, but it's a bridge too far for me to grow marijuana in the baby's bedroom. Did anybody say that?
No one's talking to me about the marijuana itself being grown.
Just to be clear, Your Honor, the baby was the child of the other 2 people.
Yeah.
His was 9 years old, sleeping in his room with him. So she was not sleeping where the crib is at.
Okay, all right, I understand that, but still, somebody is growing, wouldn't you think? I'm trying to figure out what your mindset is.
Right.
Wouldn't the fog clear and you say, you know what, there's just something wrong about people growing marijuana in a bedroom where a baby sleeps? At any point, did somebody say, we have young children here, they shouldn't be around marijuana? And I knew it probably stank. Because we tried a case in this court, and every time they would bring the marijuana out to show to the jury, I ended up getting headaches. It stinks to high heaven. So nobody thought to say, you know what? Let's set up a tent outside if we're going to do this. So at least the children won't be smelling this on a daily. That never occurred to you?
I didn't smell anything, Your Honor. From what Big was telling me, he's like cabinet.
But I mean, you knew marijuana was being grown. Are you telling me you had no idea marijuana?
I know they were, because they were working at a smoke shop. I didn't know they're actually like farming, as they would say, the marijuana.
So you're saying you had no idea marijuana was being grown?
It was not grown in my room or like in any open area.
No, that's not my
I
question.
did not, Your Honor.
So then why are you planning to endangering a child by having dangerous drugs in a household? Then if you had no idea that there was no marijuana, it sounds like maybe you should go to trial on that case.
I just didn't want to risk going to trial and then doing up to 10 years in prison. I can't do that to my daughter, Your Honor.
Well, no, this is the state jail felony.
2 years, okay.
That's the state jail felony. And then on the other one, they charge you with possession. So are you saying you didn't possess any drugs? There was no care, custody, and control?
On my room or my area? No, Your Honor.
All right. Does he want a jury trial? He's saying.
Your Honor, I think without him understanding it, the fact that he lived in the house, the fact that there was stuff in the house, I'm not saying, and I can't say on his behalf that he knew personally. I suspect that he had an idea of what was going on because of the business that his ex-wife and her new husband worked at. But I think because he was always gone, he was making plans to get out of the house. He just wanted to leave. And the problem is the incident occurred that brought everybody into the house. So when he and I talked with him, I asked him the same questions. He basically indicated that I think it was a selective ignorance. He didn't want to know, although, like you say, the smell, the signs that were on the walls and things of that nature, if you looked at the videos, would indicate, and where they worked would indicate there was something going on.
So the other co-defendants, what is that, your ex-wife?
My ex-wife, correct.
So you were living in a house with your ex-wife and her new husband?
Yes.
Oh, no, I'm just wondering.
I know it's a strange situation, but we
I've
actually
seen that on TV, but okay.
But at start, of course, it was a little rough, but we actually get along, so it was working out okay. And I was actually living in my own apartment before, but with a discussion with my ex-wife and myself, that our daughter was having a hard time me being out of the home. So after my lease was up, I actually went back into the house so we could be together until she was a little bit more understanding of what was going on. For me to leave again. Yeah,
All right. So do you live in the household now?
it's a different house with them
No, but you're not living with the ex-wife and her new husband.
together. So yeah,
So you all are still living together?
it's just been hard financially wise, Your Honor. They actually did help me out by paying my bond. Well, I paid the bond myself and they did reimburse me because they realized the situation they put me in. And I'm just trying to get everything financially wise done so I can actually move out.
So who is your family support other than your ex-wife and her new husband?
All my family's out of state here. I have
All
my
right. And
family
what state?
in Florida.
So do you want to transfer back to Florida or no?
Transfer back to Florida?
I mean, move back to Florida and have your probation transferred to Florida.
I'd like to keep it here, Your Honor.
And are you employed?
Yes.
What do you do?
I'm with the San Antonio River Authority. I'm as a landscape technician.
All right.
You would see me out driving around here.
All right. So they said that you had a family-based service plan?
Yes, family plan, correct.
All right. So what did you complete
As
with
far
the
as
family-based service? What did they have you do?
I voluntarily submitted a hair follicle test. That way I could have contact with my daughter immediately upon getting the results. And then I also did see a few more UAs after that with the
Did
family
you
plan.
complete any parenting classes?
Parenting classes themselves, no. But we did do as far as like visitations from CPS.
I don't know why CPS didn't have them do. Here's the thing, I'm going to order parenting classes because you need to realize how your actions impact your child. And I don't think people realize that because a child can't say, I don't want to live in this situation. I don't want marijuana in my bedroom because they're a child. They're not an adult. You understand?
I understand.
All right. In cause number 2025 CR 011977, there's going to be a $1,500 fine that will be probated. 3 years deferred adjudication concurrent with 2025 CR 007562A. Regular reporting by Zoom or in person. Regular random UAs or patch. The patch is more expensive, but it has less time constraints because they will put it on you. You're not allowed to remove it. You'll just report and then they'll remove it and they'll see what the testing says. Field visits 1 time per month until further notice. Proof of employment within 45 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. There's to be no harmful or injurious contact with Skylar Reyes. And there is to be a TAP evaluation. Follow recommendations. Is there anything else that you need from the court in that cause number?
No.
Probation, is there anything else under that cause number? In that case, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. In 2025 CR 007562A, the court is going to sentence you to a $2,000 fine. That will be probated. This will run concurrent with 2025 CR 011977. There should be proof of employment within 45 days. No employment as a home health care provider or with minors. regular reporting by Zoom or in person, regular random UAs or the patch, field visits 1 time per month until further notice, 3 years deferred adjudication, 200 hours of community service restitution. I'm going to order the MRT. Once the MRT is completed, the community service hours will be deemed satisfied. Probation, is there anything else that's needed? All right, and I didn't order the top evaluation in that cost number since you already have it. Is there anything else you need from the court to be successful?
Oh, yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal and
Yes.
that cost number?
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. This is what you have to remember in your life as you go forward. Until your child is an adult, they're dependent on you to make good decisions for them. They can't just say, oh, I'm going to do something else, because they're dependent upon you. And what I can tell you, even when they become adults, they're still going to be dependent on you. So you're going to have to start making better decisions if you truly love your child. You understand? All right, good luck to you, okay? In this court, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with the court, okay?
Thank you, Your Honor.
All right, you're welcome. Good luck to you.
Please.
Yes, he'll need to talk to probation.
All right.
Yeah.
Now, if doesn't, I'll see that. We've got something.
Yeah.
I'm not sure.
Thinking of him.
Sure.
I know.
Yeah.
All right, just give me a moment.
Yeah. What? Federal code. So, I have another. Yeah. I just had that work.
All right, anyone else ready?
Yes, ma'am.
All right. Juan Alberto Martinez.
All right, let's play now.
All right, State, are you ready?
Yes.
All right, the court is calling 2025 CR 004887 State versus Juan Alberto Martinez. Could I have parties announce?
Megan Gallery for the state.
Robert Featherston representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, first things first, defense, you requested a PR bond for your client and the defendant was to be interviewed. Is that correct?
That is correct, Your Honor.
All right, the court is in receipt of the interview report. State, have you had a chance to review it?
No, Your Honor.
All right, if you'll pass that to Ms. Lee. All right, thank you. All right, defense, is your motion?
Thank you, Your Honor, by way of proper. Judge, Mr. Martinez has no bank accounts, no personal property.
I'm sorry, just a moment. Excuse me. If y'all could wait to we're on the record, counsel, you may continue.
Thank you, Your Honor. No personal property of no vehicle, no boats, no real property. He relies on his mom down in Laredo. His home is in Laredo. Judge, the court does need to know that there was a violation report on May the 13th for failure to take a drug test while he was down in Laredo. Judge, the testing agency down there in Laredo demanded $75 from him that he just did not have. And was unable to get his testing completed. Judge Castro went ahead and increased his bond to $25,000, and he's been in custody ever since and being picked up for that bond increase. He was originally given a PR bond back on February the 26th of this year by Judge Navra. Very respectfully requesting that the court consider putting him again on a PR bond and allowing him to reside in Laredo during the pendency of this case. Any possibility of giving Mr. Martinez a break on any drug testing charges would be appreciated if this honorable court were able to do so. And I thank the court for its time.
All right, State.
Yes, Judge. So I would just ask you to take judicial notice of the court file, but I just want the record to be clear. The defendant was granted a PR bond on February 26th of 2025 in the amount of $10,000. And he bonded out, and then he received the violation report on May 13th of 2025 for non-compliance, and that was for failing to complete the random drug vaccine. And then after reviewing, I guess, defense's exhibit of the PR interview, it would appear that the defendant proceeded to pick up 2 new cases in Laredo, Texas while he was on bond. And so given those facts, I think he's a flight risk based on what I read. He has sufficient ties to Laredo and it appears like he has family that lives down there. And I guess if he was living with his family, that family, when he picked up those new cases, I don't think that that's a good environment for him to return back to. Additionally, give me just a second. I think the record is clear that, I mean, the PR bond was not sufficient for him to appear in court because he was previously been granted one and did not appear after that violation report. That's why the warrant went out. And I don't think he was picked up again until he was booked in Laredo and then extradited back here. So we believe that the bond is set and is sufficient. And I would also offer State's Exhibit B1 for the purposes of this hearing.
All right, have you?
No objection for purposes of this hearing.
All right, then States B1 is admitted for purposes of this hearing only. Just give me a moment to review.
Thank you, Your Honor.
All right, the court has reviewed States Exhibits B1 and the court has reviewed the PR bond interview with pretrial services. Any response to the state's argument?
If the court will allow.
Yes.
Judge, there really is no evidence in front of this court with respect to flight risk unless you consider Laredo itself to be a flight risk. But there's no testimony that he had connections across the border. There's no testimony that Spanish is his principal language. Really the only issue with respect to flight risk would be to say that his principal residence is Laredo. He has 2 new allegations against him, but they're allegations down in Laredo. If the court grants a PR bond here, he has to go back to Laredo to answer those new allegations. So that he'll be transferred by the state back down to Laredo to take care of those particular issues. Should have nothing further.
All right, thank you. All right, after reviewing state's exhibits in the pretrial services interview for a PR bond, the motion for, or the request for a PR bond will be denied.
Okay, thank you, Your Honor.
All right. And then are you all ready to take up this other motion?
Judge, I need more time to get with my office to see if we have the resources to do what's outlined in the CCP or if we need to do the in-court. So if I can have a little bit more time on that.
And so counsel, the court understands that whatever the state's resources are, there or lack thereof, doesn't play a role in the court's decision on what should be granted. Like if there's not funding for something, I'm going to follow the law whether there's funding or not. So
thank you, Your Honor. With respect, well, 2 things. With respect to the bond hearing today, would the court reduce his bond from 25 to a different figure of?
No.
You want to keep it at 25?
Yes.
With respect to the identity hearing, Judge, we would like to have the identity hearing as quickly as possible, pursuant to the court's calendar. And also in my motion, I requested a protective order that the detective that's the subject of the identity hearing not be shown any booking photographs of Mr. Martinez until after either an in-court lineup is done or the Code of Criminal Procedure 7-photo lineup.
All right, well, let's do this. Let's have you, if you'll confer with the state on a time to have this hearing, and then if you all approach the coordinator and let me know what time you all have agreed upon, and then we will set it and we'll have it.
You're most kind. Thank you.
All right, thank you.
Just one question. Do you want that hearing like around the jury trial, like we're doing it on Monday and beginning the jury Tuesday?
We could do it that way because I know we haven't set a jury trial in this case. I mean, a jury trial date.
That's correct, Judge. We
Because their
have,
final discovery is October 20th.
that's correct, Judge. And the issue is now, he can't make his bond.
Okay.
So he remains in custody. However, if we get an identity hearing done as quickly as possible, it may turn out that the state is going to dismiss this case based upon the results of the identity hearing. Conversely, if the identity hearing does not go this way, it may end up in a plea.
Well, let's do this. With regards to the identity hearing, it will be no later than October 20th.
Thank you.
But if you all are able to come to an agreement to have it sooner, then we'll have it sooner. But at the latest, October 20th, because you're already set here in the court on October 20th for discovery.
Does the board have a preference as to whether it would be a in-court live lineup or whether the photographic procedure would be sufficient?
I'll let you confer with the state because they're saying there may be some resource issue. So maybe if you confer with the state, maybe y'all come to an agreement that it's a photo lineup if I grant your motion, or y'all may say in person. I don't know if they can find people in person. It's sort of, it reminds me of the episode of Brooklyn. What is it? Brooklyn Nine-Nine?
Oh, yeah.
Where they do the lineup. And when they do the lineup, the lady says, I just remember them singing that way. And so he said, everybody sings a note. So I don't know if they'll be able to find people to come in for a lineup. They may only be able to do it by photo.
Well,
unless we have some actors. I don't know.
Judge, I understand that. Years ago, in Travis County, we had to do a pickup jury where the bailiffs went out in the hall and just found people, pulled them in, and then they became jury master.
Oh, wow.
So, we have that option here if necessary.
All right. Well, just let me know. And if you all get together and give me an idea of when you all want to do that. And as I said, Mr. Martinez, the latest will be October 20th.
Thank you, Your Honor.
All right. Thank you. Thank you, counsel.
Yeah.
Sorry, who? Yes. Anyone else?
Yes, but I just need to see.
Thank you.
Yeah, no. Blind.
Alexandra Alvarez?
Yes.
All right, Alexandra Alvarez, she is in another county, Guadalupe.
Right.
All right, so what have you all discovered?
So, Your Honor, I did confirm that the murders alleged are illegals. There are multiple cases pending out of Guadalupe. The state has given our recommendation on the motion to revoke, and it's my understanding that it will be contested. So I guess at this point, we're asking for a contested hearing, at which time defense counsel can discuss with the court whether her client can appear via Zoom. So.
All right, do you have any objection to our client appearing by Zoom?
No, Your Honor.
Is there going to be an objection to your client appearing by Zoom?
I have no objection.
All right, Ms. Ferguson, we need a contested hearing on Alexandra Alvarez. She's in Guadalupe County Jail. 10 days, please. Because we were actually scheduled for a contested on February 20th previously, but I believe she got picked up. October 13th? All right, so it's going to be October 13th.
That's fine.
And Ms. Ferguson, if you'll make sure that she's ordered from Guadalupe by Zoom. Yes.
Maybe excuse me.
Yes, thank you.
See, I'll see you on it. Thank you.
This is the first time I've worked on my bill, which is. Yeah, I don't have access to government. Okay. Christopher?
Ms. Abrams, that's a true contested. Just a moment.
Oh.
Actually, awesome. I know.
Okay.
And is this on today's docket or no?
Yes, it is, yeah.
All right. And what page is she on?
I didn't have a chance to look at it, Judge.
All
Sorry.
right. It's Juliana Maldonado Guevara. Thank you. All right, you all sign in?
No, they brought Mr. Guzman.
Y'all need to sign in,
Okay.
yes. All right, who's next? Yes? All right, thank you.
The next one is Brianna Luna. Page 32 down. Judge.
Brianna Luna.
Morning, Your Honor. I would confess on behalf of Brianna Lynn. Do you want her up here?
Yes.
Brianna?
Sorry. What's going on? Yes.
How are you, Judge?
Doing great. How are you doing?
I'm doing good, Judge. So good.
Oh.
Year's winding down, another year.
Oh, hey. Hello.
This is Miss Lynn.
Hi. So why were you late for court? No, docket was called at 9. You didn't answer. All right. So here's the thing. You need to be in court at 9 for when docket is called. Otherwise, when I call the docket and you don't answer, I'm assuming you're not here. Okay. So you're more than welcome to talk to your attorney outside in the hallway, but wait till docket is called. All right. So where are we on this case with regards to discovery?
Well, we thought we were missing 3 items and Ms. Galloway just informed me that she heard back from them. And they don't exist. So I think discovery wise, however, there's some records we're trying to locate California.
What records?
Mitigation and mental health records.
All right. And Ms. Galloway?
Yes.
Were you able to tender your offer?
Yes.
Yeah, I've got the offer.
All right. Ms. Ferguson?
Yes, ma'am.
Set this for a plea deadline date in 45 days.
Yes, ma'am. I think November 13th.
All right, so your plea deadline date is going to be on November 13th. On that day, you need to let the court know whether or not you're accepting or have reached an agreement with the state. If you have not reached an agreement, your next setting is going to be a jury trial setting. Do you understand? All right, and counsel, Ms. Galloway, on that, if you all can give me an acknowledgement of discovery sign, please, before you leave, and then you're excused once you sign the reset form. All right, and thank you for dressing appropriately for court. All right, have a good day, okay?
Thank you, Judge. Get that form in.
All right, thank you. All right, who's next? Richard Ibanez. Hello. Hello. Thank you for dressing appropriately for court. I appreciate that. All right, so are we here for?
So this is a compliance hearing. We're here because his original condition, Mr. Ibanez's original conditions of probation indicate to bring him back to court if he did not get accepted into felony drug court. Unfortunately, he was rejected from felony drug court, with the outcome indicating he did not meet the criteria for substance dependence. In addition to, there was no TRAC assessment of the file to determine the risk level, and he did not meet criteria per se. However, there are some additional notes, Judge. At this point in time, we're asking that Mr. Ibanez be referred to Veterans Treatment Court. And we're asking that a TAP evaluation be expedited.
That is correct, Your Honor. Speaking with the Community Supervision Department, as well as my client, it seems that there have been some indication. I know the court at the last hearing did notice some indication of usage. However, it seemed to maybe sporadic and not to the extent of heavy use, which is why I believe he was not accepted to felony drug court, Judge. I have advised Mr. Ibanez about AANA in the meantime until that TAP can be conducted, as well as he had the opportunity to speak with Mr. John Herman with VTC regarding potential resources as well. So we would echo that request of the VTC referral being made by this honorable bill.
All right, and did you all get a date for when they think they will have everything ready?
Judge, no, I did not ask him a date. I just asked him to speak with him to see if he would be a good candidate. I can reach out to him and ask him when he thinks it will be staffed.
All right, so how much time do y'all think to bring this case back? How many weeks?
I think, Your Honor, maybe for things to take hold and potentially tap 45 days if the court is not opposed.
All right. If you're drug tested today, what are the results going to be?
Okay.
All right. All right, Ms. Ferguson, your 45-day reset. All right, so we're gonna come back on November 13th to get an update on felony Veterans Treatment Court, okay? November 13th. They'll give you a reset form, all right? Okay. All right, thank you so much. And thank you for your service. All right, anyone else? Ruben Rendon. Hello, sir. Come on down. Who's the attorney for Ruben Rendon?
Oh, Chandra, he's in the room, Judge. Okay, yeah.
All right.
Could you get him right now, Judge?
All right, thank you. Don't run.
Oh, wait, see. Right.
Yeah.
All right, just have a seat. And we'll take you up when your attorney is here. Who else is ready?
Tasha Manning, choose me down.
Natasha Manning.
Yeah, we haven't already.
Hello. All right, so where are we on this case?
Yes, Your Honor, discovery seems to be complete. We do have the discovery acknowledgement for the court if I may tender.
Yes.
Thank you, Judge. I know we're on record in speaking with the state of my client, Your Honor. Seems like there's some treatment concerns, issues for the mental health. She's a veteran as well, Judge, served this nation honorably. She did also speak with Mr. Herman, who was here about the Felony Veteran Treatment Court program, Your Honor. Being that the discovery, in our opinion, is complete, we know what kind of options would be most beneficial for Ms. Manning. We wanted to see about the potentiality of a Felony Veteran Treatment Court.
All right, Ms. Ferguson, I need a referral for a felony veterans treatment court, and we'll recall this back on November 13th.
Well, thank you, Your Honor.
All right, thank you so much. Once you sign the reset form, you're excused, okay?
Okay.
Thank you.
Let's see, I'll come back.
All right, who else is ready?
It's 9-1 down.
Christian Holligan.
Oh, okay, thank you.
Sure.
Thank you. I didn't.
That's okay.
I believe it's pronounced Hogan.
Hogan, all right. Hello, Mr. Hogan. All right, why is your daughter not with us? I'm used to seeing her now. Is she back in school or studying?
Yeah, she took the LSAT.
Yay.
I've given up to taking a different. I'll tell you something. I think she did great, but she's for the stars.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to?
You can only take it 5 times.
Oh,
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories. Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th. Yes.
All right, just 1 second. Okay, there's nothing attached to this.
He said that the DA's printer person lost ink and it was emailed to them.
I'll accept, I'm fine with service by email. That's okay with me.
Okay, all right, thank you.
I wrote it on there too, Judge. Email to the best guy.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Hard time for the county judge.
All right, thank you. And then on Hogan, I don't have the motion to revoke file. Hogan. Oh.
It should be printed up there.
Right, all right. And so it's set for today. And what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Rashad is bringing it.
Oh.
Thank you. We made it. So the only thing that I see that's been added is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number one.
All right, do y'all have labs for that?
We do not, it just occurred.
Then labs, are y'all expecting to have those labs in 10
No,
minutes?
I told counsel, there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing because they're not going to be prepared to proceed on the violation of condition of number one, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So really the only thing that's going to be proceeded on is probably the original.
Revision.
Yes.
Can we go on that right now? Yes.
State.
May I see the,
Yes. And just mention the one thing.
sure, Your Honor, yeah. We, just so the court knows, on the original, the other new number one, the evading was dismissed by our office. So literally the only thing left is the number two.
Okay. Do I have a file stamp, please? Yes. So is this a case that criminal trial division or is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're gonna plead true to it.
Okay. So I don't know if who's going to be making the recommendation on their side.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 0077778 State versus Christian Grant Holguin. Can I have parties announce?
Melissa Alvin for the state.
And Eric DeWalt, I represent Mr. Hogan.
And are you Mr. Holguin?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Holguin who was placed on deferred adjudication in 2024 CR 0077778 for the offense of assault family household member impeding breath or circulation on October 31st, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
You can proceed on number two, Your Honor. On or about the 15th day of August 2025 in Bexar County, Texas, the defendant Christian Grant Holguin did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number two.
How do you plead to that? True or not true?
True, Your Honor.
State.
We'll waive the rest, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violation of condition number two, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
May I speak on that?
No, my question is, do you understand
Yeah,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number two? Court will find violation of condition number two true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF. We would withdraw the MTR and alter and amend its conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's
Oh,
already played.
That's right, Your Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going open to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court. but wanted to address the court and ask that if he could have a less structured modality that he could continue to work. Do
All
you
right,
want to address it?
any,
Yes.
before you address me, any objection, I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next.
Or do you? have a
Oh,
copy?
yes, they emailed me.
Okay.
I receive it by email, but I don't open it until parties have no objection. All right, probation, what are you recommending?
The recommendation is for residential treatment at status followed by the aftercare and continued on the ISD case.
Is it possible to do, just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do status the first time, Judge. He did local ISF.
Ah, okay.
So as we know, local ISF is more geared to cognitive, and then the SATA has that substance abuse. I was in the midst of looking up why he did not qualify for drug court, if you would
Yes,
like to know that.
yes. And then you want to raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Brett Hogan.
All right, so it appears there's something you wanted me to
Yeah.
hear. Did you want him to speak to me, counsel?
That's his intention. It's your intention to address the court, correct?
Yes.
I just want to let you know, member, I understand this, what they're recommending. I just feel like, and you've been fair since I've been in your courtroom, ma'am. I already completed ISF, which, yes.
So here's the thing, let's get to the crux of the problem.
Yes,
The
ma'am.
problem is you didn't report for your UA. Why?
One time, ma'am, I was
No,
there.
no, no, let's not do the one time.
Well,
It's one time is enough. Wait. We have to speak one at a time.
Okay.
And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, ma'am, I'm gonna get to that. I was doing well. I was remodeling homes with my brother, and I was always in contact with my probation officer, and I had just lost my efficiency, ma'am, and so being in the streets, having my things stolen, lost the storage, and so and these are not excuses, ma'am, these are the truths. I had trouble with cell phone, and I always made sure I emailed when I didn't call her, and so fast forward to the motion to revoke, I had just spoke with her, I want to say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishing, and I went to the hotel, and it was just hard, ma'am, and that's just all I can tell you.
Here's the thing, I'm gonna give you a choice. These are your choices. There's no other choice, right? Here's your choice. I can revoke you and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive supervision. And I'm going to start you off with GPS. And that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am, could you please waive the fees on the GPS?
Yes.
Yes, ma'am, I can do it, ma'am.
All right, Ms. Abrams,
Thanks.
I'm going to deny the motion, alter and amend conditions to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation.
Yes, sir.
Is there anything else?
Nothing from the state, Your Honor.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You helped me out with everything, Ms. Boyd.
You're welcome. Anything else?
And I just clarified, he's on deferred adjudication, correct?
Yes.
Okay.
All right, thank you.
Judge, thank you for all your consideration.
You're welcome.
Appreciate
You're
it.
welcome. Anyone else ready? All right, Rendon. All right, all right, court is calling 2024 CR 011707 State versus Ruben Rendon Jr. Can I have parties announced?
Sean Sheffield for defendant. We're ready now.
And are you Ruben Rendon?
Yes, Judge.
All right, did you review the documents entitled Motion to Revoke Community Supervision, First Amendment Motion to Revoke Community Supervision, and Second Amendment Amended Motion to Revoke Community Supervision? Did you receive that and review that with your attorney and understand it?
Yes, Your Honor.
Are you the same Ruben Rendon Jr. who's placed on community supervision in 2024 CR 011707 for the offense of robbery on February 3rd, 2025 for a term of 8 years? Is that you?
Yes, Your Honor.
All right, state.
We're going to proceed on the first two on the original, Your Honor. The only one on the second amendment. In Bear County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to report to the supervision officer as directed for the months of June and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And on or about the 12th day of June 2025 in Bear County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to comply with the rules and regulations of felony drug court, in that the defendant failed to appear in court in violation of condition number 41.
How do you plead to that?
Your Honor.
And lastly, in violation of condition number 1 on the second amended, on or about the 31st day of August 2025 in Bear County, Texas, the defendant, Ruben Rendon Jr., committed the offense of failed to ID in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive the rest.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 4, 41, and 1, the court could find it true, grant the motion, and sentence you up to 8 years up to 10 years in the prison? Knowing that, do you still wish to plead true to violation of conditions 4, 41, and 1? Court will find 4, 41, and 1 true. Is there a proposed agreement?
There is not, Your Honor. The state is recommending revocation and 6 years TDC.
All right, defense, what are you requesting?
We're requesting actually the recommendation from the probation office is that he gets additional help for drug issues that he has. We're asking the court to follow that recommendation. We're asking for safety. He understands that he would have to leave. He's willing to do so. He also told the court that he has a problem. He did complete the lifetime inpatient. However, once he was released, he had some issues after that.
All right, is there anything you wish to say?
Your Honor.
Can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Ruben Rendon Jr.
All right, what do you wish to say?
Your Honor, I did learn a lot from the good people at Lifetime Recovery. And the one thing I didn't follow through really messed me up, and I stayed with her. I should have changed the people, places, and things like Darnell taught me, and I did not follow through. And I know that if I'm given this chance, Father, Your Honor, to do this again, I know I've got to do this right. I have grandkids, and I definitely don't want to be put away for the long time that they're trying to put me in. But I definitely know I can get this right, and I need to get this right. Your Honor, I'd like to please have this chance.
All right, so Mr. Rendon, felony drug court is a very intensive program, and they're there to help you. And if you don't show up for them, then nobody can help you. And it appears that you stopped showing up. And I know that felony drug court will spend time trying to work with you. Even if you were to abscond, they will send people out. I've seen probation officers try to go out and find people. The police try to go out and find people. But when you don't show up, there's nothing that we can do. I'm going to grant the motion, revoke you, give you credit for any time served. I'm going to sentence you to 5 years in the prison, give you credit for any time served for any successful inpatient treatment. And I'm going to request the therapeutic community for you. Therapeutic community doesn't increase the time that you're in custody. However, it does help you with any addictions you may have. Do you understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. When you're released from prison, if you cannot find a sober living home, or if you can't find somebody to help you with your drug addictions, if I'm still here, you come back here. I'll pick up the phone, call a place to help you, okay? All right, thank you. Who else is ready?
Michelle, are you ready?
Yes.
All right, Raymond Elizondo. Yes.
Judge. A supplemental report was submitted to the court judge on 9 and was signed on 9/15 in regards to Mr. Elizondo having his conditions amended to have contact with his children.
Mm-hmm.
In the supplemental report, there was some information in which you said you wanted to have a hearing.
Okay. All right, so Mr. Elizondo, if you can unmute for me, please.
Yes, ma'am, I'm here.
All right, so have there been any type of civil orders that have been in place with regards to your having contact with your minor children?
Only just the court order on the probation side.
No. So anyway, you'll have to take care of this civilly. Based upon what I have in the supplemental report, the court is not going to lift the no contact orders.
Okay.
And part of the reasons why I'm not going to lift the no contact order is based upon your actions.
And why is that, ma'am?
Because what I've seen in here and what I'm reading, the complainant is saying they do not feel safe. And the complainant has has to continue to move from place to place to avoid you. So if you want to have visitation with your children, number one, whatever they do on the civil side, I'll take that in consideration. They're probably going to have an amicus attorney or either an ad litem for the children for the court to consider. But you're going to have to start with the civil issues first, and then I will look at those reports and consider it from there.
Yes, ma'am. Well, when I had went to court, they had told me just to try to get it amended, and then that way they could shadow that, and then they would move forward with me being able to see my children.
Who is we?
When I went for the court in front of the Attorney General.
Oh, no. See, that's what I call passing the buck or kicking the can down the road. They're passing the buck to me. And guess what? I don't have an amicus attorney here to interview your children. I don't have an attorney ad litem to speak to your children. They have that on the civil side.
Okay.
I only have jurisdiction over you because you're out of this court. I don't have jurisdiction necessarily over your children to make a decision on what's in the best interest of your children. They're supposed to be doing that at the AG's office or in Child Protective Services or in family court, most importantly on the civil side.
Yes, ma'am.
All right. So once that's taken care of and I receive reports, I'll review it and then make appropriate rulings on this side.
Yes, ma'am.
All right. Thank you.
Thank you.
All right. Anyone else ready?
Yes, ma'am. It is page 6, 5 down.
All right. If you all have already signed in and I haven't called you, it's because I haven't been told that you all are ready. So if your case hasn't been called, you may want to approach. Christopher James Falk.
Here you are.
Yes, please.
Sorry.
All right. So where are we on discovery?
Your Honor, we do have an outstanding subpoena that I have followed up with, and we are trying to contact the school district in North Carolina to get. So we are just waiting on that. I believe we have all other records that we've ordered.
All right. And so those are school records.
Yes, Your Honor.
And when do you expect?
We have already sent out a subpoena. So I believe that was sent out on 9/19.
All right. Ms. Ferguson, I need a 30-day reset for discovery. Hello. Good morning. All right. So we're going to come back on October 30th to see where we are with discovery. Is there anything else, counsel?
You know, I've talked to the state. I couldn't get any discovery at all on the discovery module, so I'm going to give her a flash drive or whatever.
All right. Thank you. Thank you.
Thank you, Josh.
Thank you. All right. Who else is ready?
It's Richard Guzman. Okay.
What page?
It's an add-on, Your Honor. For,
All right. Do you all have the case number? All right. Where's Mr. Guzman?
It's coming right in.
Oh, yes. Okay, no problem. If you can bring him up. Willie Fields.
And
Mr. Fields, is he here?
Federal custody, Your Honor.
All right, so can you tell me what is the update?
Sentencing is scheduled for December 17th.
All right, Norma, if you can set this in January.
January 6th.
All right, and I'm so sorry. What date did you say federal sentencing?
December 17th is when it's in.
All right, so we'll see you back on January 6th.
Thank you.
All right, thank you. And state on Fields, if you make sure that there's a bench warrant for him, his federal sentencing, they tell me, is December 17th. Yes.
Can you take it to him?
And just remind them. All right, who's next?
Page 3 went down. Stay on.
Oscar Orozco Narano. All right, just have a seat. Who else is ready?
Page 5 down.
Christopher Fields. Hi, how's it going? I'm loving the talk.
Thank you. I'm like pre-rodeo.
You know, my mom bought me my first pair of cowboy boots. They were burgundy with, you know, the designs on the side, and it was cream and burgundy. I love those boots.
Oh, do you still have them?
I think my mom still has them, and I think they still fit. Because my size hasn't changed from when I, you know, still 8.5.
There you go. Yeah. My 13 months.
Oh, yes. All right, so
Mr. Fields is not present today. I am in contact with him. I'm asking if he could recall it for tomorrow morning.
okay, is there a reason he's not here?
He says he was not informed of the court date. My office did not call him and tell him about it. He has been checking in with his bondsman weekly. He's been appearing at his misdemeanor court dates and focusing on this.
All right, so what I can do is I can recall it for Thursday. All right, Miss Ferguson, On Christopher Fields, that's being recalled for Thursday. All right, thank you. Have a good one. All right, who else is ready?
Antonio Vasquez, George Barrington.
Antonio Vasquez.
Vasquez.
Who's the attorney for Antonio Vasquez?
Chris Ramos.
All right, just have a seat. He's not here. Who else is ready?
Pete White.
Is Nathaniel Navy here?
Oh.
All right, Doick, Yanes. All right, hello. Court is calling 2025 CR 004-334, State versus Doick. Yanes, could I have parties announced?
Lauren Espinoza for the state.
Nathaniel Navy for Mr. Yanes.
And are you Mr. Yanes?
Yes, ma'am. Your Honor.
All right. Have you, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes,
And
ma'am.
sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
You're welcome. Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft of property, $30,000 to $150,000. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
He is currently competent and was legally sane at the time of the offense.
Yes, Your Honor.
Mr. Yanes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering into this plea, if you're not a U.S. citizen, you will be denied naturalization? You okay, Cindy?
Yeah.
Do you need a cough drop?
Yeah, I've got one.
Right. You will be denied naturalization, deported, and not allowed to re-enter. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it and sign it?
Yes, ma'am.
Right. According to the plea, there's $1,000 fine. State recommends deferred adjudication. They'll take in consideration CM 108679. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
So, Your Honor, there have not.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution. And I'll slow down for this part. No contact with Nordstrom's, Rack on IH-10. No contact with Walmart on Vance Jackson. Best Buy at La Cantera. REI at I-10. Dillard's La Cantera. Bass Pro at IH-10. Tommy Bahamas at La Cantera, HEB at Zazamora, Barnes and Noble at La Cantera, Nordstrom's at La Cantera. Is this ALOE?
Hello.
Oh, Aloe at La Cantera, Target at La Cantera, The Container Store, Northwest Loop 410, Saks off Fifth at North Parkway. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead?
No comment.
State, any evidence?
Yes, Your Honor. State offers States Exhibit 1 and all attachments.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So here's the court's question. Is there any restitution that's owed?
No, Your Honor, all items have been recovered in this case.
All right, so what were you taking from Barnes and Nobles that totaled $7,900?
Just reading books.
No, I mean carrying books out of Barnes and Noble or trying to carry books out of Barnes and Noble, $7,000, well, $7,900 of books out of Barnes and Noble, that's a lot of books to carry. Even if you're doing anime, even if you're doing paperbacks. So why are you doing this?
I was just down at the time. My mom had passed and I was just doing stupid things that, I corrected.
Are you employed?
Yes, ma'am.
What do you do?
I work at Dutch Warrior, 5-star cleaner, I'm a fleet manager.
All right. So does he need mental health treatment? What's going on here? I don't understand.
I'm not, Judge, I'm not aware if he does for certain or not. I don't think it would hurt to at least have an evaluation. My understanding, all the merchandise was recovered. So it wasn't a situation where Mr. Yanez was selling this or, no.
I don't,
Anything like
so I'm trying to figure out, Mr. Yanez, how do you go from you've had a death in family till you're stealing? I don't understand.
I was just, bored down, nothing to do.
All right, this is what the court is going to do. There's going to be $1,000 fine that will be probated. Sure.
Okay.
All right, there's $1,000 fine that will be probated, taking in consideration CM 108679, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Let's do a referral to Center for Healthcare Services and a MIC evaluation. Four years deferred adjudication. There should be no contact with the following. There should be no contact with La Cantera. And I think it's called the Shops at La Cantera. There should be no contact with Best Buy, REI, Dillard's, Bass Pro, Tommy Bahamas, HEB, at Zamora, Walmart at Vance Jackson, Nordstrom, ALO, the Container Store, Saks on or off Fifth. All right, I'm really torn about not allowing you to have contact with Barnes and Noble because we're losing our brick and mortar bookstores, but then can't have you committing a theft. So I'll just do no contact with Barnes and Noble at La Cantera. There should be 120 hours of community service restitution. And I'm gonna order CATS theft course 1 and 2. And once that's completed, the community service hours will be deemed satisfied. Probation, is there anything else? Field visits 1 time per month for 6 months. Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. I understand about death of close family members. I've had it happen to me, but you just can't become lawless, right? If there's something you need help with, then you need to talk to somebody. And I know sometimes people are embarrassed that they don't want to talk to a therapist or a healthcare provider, right? I can tell you in the Black community, I shouldn't say the entire Black community. I know with my upbringing, people, there was not an encouragement to go talk to somebody and get help.
Yeah.
It's like, go talk to God about your feelings, which you can still do, which I still do. But in this day and age, when you see that your life is falling apart because through loss or whatever it may be, and you need somebody to talk to, the best thing to do is go talk to somebody and not commit an offense, because then this is just stacking problems on top of problems. Okay. Right. And I don't think your mama wants you to do this.
Right.
Okay. All right. So in this court, to be successful on probation, communication is key. If you have an issue, let probation know about it. And if you feel they're not addressing it, you can always come back to me. Okay. And so I set you up for you to have a mental health evaluation with us, but also you can go to Center for Healthcare Services. And sometimes you just need somebody to talk to, like a complete stranger, and you can do that. And I want to say NAMI has a free number that you can call. And let me give you, I'm going to give you their number and you can call them. And when you call them, they have a mental health hotline and it's a complete stranger. It doesn't cost anything and they will help you. And that's the number, okay? So, you can call them anytime, day or night. They have somebody working the phone lines 24/7.
Oh, okay. Thank
All
you.
right. Good luck to you, sir.
All right, thank you.
Thank you so much, Judge. Have a good day.
Thank you, you too. All right, anyone else ready?
Yes, Samuel, you want to speech 5, sit down? Karen Bobby, ready?
All right, Samuel Lamone.
Morning, Your Honor.
Good morning. I'm telling you, my typing is off today because I started without my hands on the home row keys, and once you do that, it's over. Oh my gosh, what?
I know, nobody believes me, but it's true.
And I would always see them in the old movies pecking. I'm like, surely nobody does that. But now I know Karen Corby does that.
Well, I did know ASTF JKL semicolon, so I kind of like, I have to look, I can't look around.
Ah,
It's crazy.
so on this case, where are we on discovery?
Well, this our judge, as far as I know, they gave us everything.
And was an offer tender?
Yes.
And how old are you?
22.
All right, Ms. Ferguson, recall this for 30 days for plea deadline date.
That would be October 30th.
All right, so we're going to be back on October 30th, and you need to make sure you're on time for court. Court starts in this court at 9 a.m. If you're not here, what will end up happening is a warrant may be issued. You understand? All right, once you sign the reset form, you're excused.
Thank you.
Just have a seat. Thank you. All right, who else is ready?
Antonio Vasquez, speech 5, 4 down.
Antonio Vasquez. Hello. Antonio Vasquez, are you coming?
Coming up.
And counsel, while your client is coming up, where are we on discovery?
I cannot find the video recording of the complainant making her statement to police. So my request is to, maybe we can reset 2 weeks, maybe 3 weeks.
All right, is this criminal trial division or family violence?
Criminal trial.
All right, criminal trial division on Antonio Vasquez, page 5.
Yes, sir.
He says that there's a video recording of the complainant. He cannot find it.
Judge, I was having trouble finding it, just that kind of slammed.
Oh, yeah.
If I could have just, I did see that there was a mention of it in the report, but I haven't been able to download it onto my computer to give to them.
All right, so what we'll do is we'll recall it.
Okay.
Ms. Ferguson, recall this in 2 weeks for discovery.
Yes.
All right, we're going to bring you back on October 14th to make sure that your attorney has all the discovery, okay?
Okay.
All right, do you have any questions?
All right.
All right, thank you.
Yes, ma'am. Thank you, Judge.
You're welcome. All right, who's next?
White Murphy, page 7, 2 down.
Dorian Murphy.
Jane Oaks.
All right, come forward. All right, they're waiting for your client.
Judge.
Okay, all right, we'll get to it. Just have a seat. Who else is ready?
It could be, Beverly Collins, read.
Judge, I was just, since I'm already up. Since I'm up.
Okay.
I
Are you on Leslie
conferred
Collins?
yesterday a long time on Mr. Moreno's case. He's in the guy in the wheelchair from a while back. Myself and Mr. Wright left, we went to witness room, we conferred with members back and forth. I gave him discovery.
Just give me a second.
Yeah,
Let me
just
pick
like-
this up and then I'll come to that.
Let you know where we were.
All right, Leslie Collins.
If I'm being for. Yeah.
Come on.
Hello, and where's Leslie Collins? Thank you.
And then we're both here on this,
All right, awesome.
two separate cases.
All right. All right, court is calling 2025 CR 009404 and 2025 CR 009550. State versus Leslie Collins. Can I have parties announced?
Robert Almonte for Leslie Collins on cause of branding 9404. Brandon Lopez on the other cause for Leslie Collins.
And are you Miss Collins?
Yes, ma'am. Good morning.
Counsel, in each cause number, have you received all discovery? Did you review it with your client?
Yes, Your Honor. Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Ms. Collins, in each cause number, did you review the documents entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsels, do you waive the reading of the indictments?
Yes, Your Honor. We did.
State, are you proceeding on the indictments as presented?
We are, Your Honor.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
In each cause, you're charged with the offense of theft of property, $2,500. Less than $2,500 with 2 or more previous convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to accept your plea. If for any reason the court does not accept your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
You have a right to jury trial, a right for you or your attorneys to cross-examine and confront any witnesses the state may call, and the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor. Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor. Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offenses?
My
Miss-
finish is done.
Ms. Collins, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you were represented?
Yes, ma'am, I was.
If you're not a U.S. citizen, by entering into these plea bargain agreements, you will be deported, not allowed to re-enter the United States, and denied naturalization. Did you understand?
Yes, ma'am, I did.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
In each cause number, according to the plea, punishment is to be assessed at 2 years in the prison. 2 years in the state jail facility. There's a $1,500 fine. State recommends community supervision, and the cause numbers will run concurrently. Did you understand that to be the plea?
Yes, ma'am.
Yes,
Attorneys,
Your Honor. Yes, Your Honor.
state,
Yes, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. The anti-theft course, 120 hours of community service restitution, no contact with Walmart, any TAP evaluation, and random UAs. To understand, those are recommendations from the state, and the court does not have to follow those recommendations.
Yes, ma'am.
In each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, in each cause number, do you have any evidence to support the defendant's plea?
We've offered an evidence case exhibit 1, which is the contest, Your Honor.
Okay.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
All right, we're going to go off the record for a moment.
That's going to be it for today, ladies and gentlemen. Tomorrow is Judge Middleton's docket. And then on the first, I'm taking the day off. And then I will see you guys on the 2nd of January of 2026. So you all have a wonderful evening. Ta-ta and ciao ciao. I will see you guys again tomorrow. So you all have a wonderful evening. I will see you guys tomorrow. Ta-ta and ciao ciao.